Welcome, and thank you for joining me in today's webinar. My name is Helen Quinn, and I'm an executive with the Small Firms Association. I provide expert advice to our members on employment law, HR issues, health and safety, and GDPR. Sorry, I just see you probably can't see my screen yet. It's just showing up now. Okay, so today we are going to look at record keeping and GDPR, and specifically looking at some key retention periods for your personal data. So just some housekeeping before we start. Can everyone hear me? If you do not have any sound, please click on the hand symbol, which is located on the side panel. We are recording the webinar, which will be shared on the SFA website under our GDPR section, and everyone will receive a copy of the slides by the end of the week. As we go through the webinar, if you have any questions, please type them in and we will prepare a GDPR FAQ sheet, and this will be circulated to everyone next week. So, we receive many queries on GDPR on a daily basis, and the top burning issue we have receiving from our members at the moment is how long should they hold personal data for so that they can comply with GDPR. Under the new regulation, there is no actual specific time frame other than that businesses should only hold personal data for as long as necessary. This is posing a significant challenge and concern for small businesses. So before we delve deeper into GDPR and record keeping, I thought we would kick off with a poll to get a sense of how concerned you are about this. So, how worried are you about data retention for GDPR? So the poll now is just opening up, and there are 3 questions. Are you very worried, or not worried? So we're just going to spend a minute or two just to gauge the responses, and it would be great if you could participate. So at the moment, it's looking like most people there who are signing in are worried. So it's good that none of you are too very worried, and a few of you are not worried. So that's good. You're probably getting on with your preparations already. Okay, so thanks very much for taking part in that poll. The whole area of record keeping. And here I've just got the results finally. So 80% of you are worried, 7% are very worried, and 14% are not worried. So thanks again for participating. So the whole area of record keeping. So the whole area of record keeping and setting data retention periods can feel like a minefield. It can be difficult to know how long should personal data be kept for and what is the criteria to hold it. The only given is that it cannot be held indefinitely. And there is a risk if you delete the personal data at random, there's a risk that you might lose something that's gone. In preparing for this webinar, I was reminded of a UK 1970s educational advert that focused on road safety, that used the green cross code, telling everyone to stop, look, and listen before crossing the road. Today, this webinar will ask you to pause and consider before you delete personal data at random. It is the intention of this webinar to help you navigate some common themes to GDPR and record keeping before you start the big data clear out. So today we're going to explore legal retention periods for HR records. Many elements of the employee file have statutory time limits, so these records must be held for a specific period of time. Today we'll look at the more common ones, and we do have a full record-keeping checklist for employee records, which will be shared with the slides, and these are going to be added to the SFA website. We're also going to look at limitation periods and what this means, and look at a few of the more common types of claims that a business may encounter, but hopefully that won't be you. We'll also look at health and safety considerations, including retaining data for workplace accidents, training records, and other health and safety considerations. Many businesses are governed by regulatory requirements, so we'll look at these and just raise a few questions as to what you need to factor in. And we'll also look at record keeping in relation to data protection. And then finally, we'll look at individual business needs and what the objective business reason would be to hold the data. And a few of the things that we'll look at are tax and revenue records, CCTV footage, and legitimate business interests. So before we go into GDPR and record keeping, I want to share what the 6 key principles are for processing personal data. These form the bedrock of GDPR, and it is important to know what these are so you can apply them to your personal data processing activities. GDPR is a risk-based regulation. So if your business processes a large volume of personal or sensitive data, and it has the potential to cause more harm to individuals if that data is breached, then your obligations are more onerous as the risk is much higher. Equally, your risk is lower if you only process small amounts of personal data. So the 6 principles of GDPR, the first one is lawfulness, fairness, and transparency. So what this means is that there must be a legal basis for processing this personal data. This can be based on consent, a legal requirement for the performance of a contract, vital interests, public interest, or a legitimate interest. The data must be processed fairly and in a transparent manner, which means the data subject must know why and how you are collecting the data, and they must be informed of this in a clear and easy to understand language. The second principle is purpose limitation. What this means is there must be a specific reason for processing the data. For example, with employee records, you have to process the personal data in order to manage the employee relationship and to comply with employment and contractual legislation. In the case of marketing, you need to let individuals know the specific reasons why you want to use their data to contact them. And once they agree, you can only contact them for that specific purpose. You wouldn't be able to contact them for another reason unless you get fresh consent for that. The third principle is data minimization. That is keeping data to a minimum. For example, if you are asking an individual to sign up for a newsletter and you ask them for their email, date of birth, address, and maybe 7 other fields of information, you need to ask yourself, do you need all of that data, or will an email address just be sufficient? If there is an objective reason to collect the additional data, then that's fine, that's necessary. But if not, don't ask for that. That's what this third principle covers. The fourth principle is accuracy. It's ensuring that the personal data you collect is accurate and up to date. You might receive a request from a data subject asking that their data be updated or erased completely. And if you do receive this, this needs to be carried out with undue delay unless there is a regulatory or legal requirement that overrides this request. The fifth principle is the main focus of this webinar in that data should only be stored for as long as necessary. And this principle requires that businesses document how long they will retain the data and remove any unnecessary personal data that is no longer in use. Finally, the sixth principle relates to ensuring that your technical and organizational measures ensure that personal data is kept safe and secure. The recent Facebook and independent newspaper data breach scandals have really brought this into focus, and more individuals are aware of their data privacy rights. The Data Protection Commission published a really helpful publication that can help small businesses know what technical and organizational measures they should implement. and you can access this on their website at www.gdprandu.ie, and you can check it out under their resources section. So the challenge, holding data for as long as necessary. Ensuring that you hold the personal data that is needed is a 360-degree turnabout change for many businesses. We're used to holding on to personal data indefinitely for that just-in-case scenario. However, this will no longer be allowed under the GDPR, and it is posing a challenge to many businesses. And unfortunately, there is no clear-cut guidance under GDPR on how long you should hold personal data, as each business has a unique and specific data processing activities. It's unfortunate, but it's impossible to create a one-size-fits-all approach. So this change will require a change in mindset and approach to dealing with personal data. However, it can also present an opportunity. There have been some cases from member queries that they've reported that they're saving on storage costs, both with online providers and costs of archiving hard copy personal data, as well as gaining more physical space within their premises. Another element is for those who carry out marketing activities, you can be secure in the knowledge that once your lists are cleansed with confirmed consent, your list will contain customers who want to hear from you and remain engaged with your business. GDPR may help with the scattergun approach to marketing, where you might get some hits, but only after a lot of effort, time, and money. So let's move on to those key considerations for your record keeping needs. So the first thing we're looking at is the legal retention periods for HR records. So before we go into it, we're just going to do another little poll. So how long should working time records be held for? Is it 1 year, 3 years, or 10 years? And it's great to see the answers coming in. Yeah, it's looking pretty clear which one is the winner, which is great. So we're going to announce those shortly. Yep, pretty much most of you are on the money. Well done. So great. The answer is 3 years, and 74% of you got that right. And then the others, yeah, it's 10%. But if you're not looking after HR, maybe that's the reason why. Anyway, but thank you so much for participating in that. So just moving on. I'm just going to. So I'm just going to look at the more common. Sorry, just having a bit of a technical issue here. Okay, great. So looking at the so most businesses have employees, and this may be the main focus for your GDPR and record keeping activities. Under various pieces of employment legislation, businesses are required to keep certain records for a specific period of time. So before delving into this, I have another poll for you. Actually, we just did that. Sorry. Under the terms of Employment Information Act, employers have a legal obligation to retain contracts of employment or the written terms of employment. So this would be for the duration of the employment and 1 year after the employee has left. Later on, I will mention limitation periods, which will also impact the length of time you should hold on to contracts of employment. Then moving on, parental leave records need to be held for 8 years under the Parental Leave Act. And this also includes force majeure records. In addition, the notices that detail the time taken off and the reason for the force majeure leave need to be held for 1 year under the Act. So you have the records and then you have the notices. The information in these notices will contain sensitive data one of the questions might be as the reason for the emergency. So you will need to ensure that this data is properly managed and safeguarded in line with how your business treats sensitive data under GDPR. Then for carers leave records, these also need to be held for 8 years. And under the Carers Leave Act, notices to take carers leave need to be retained for 3 years. Sorry, just going back because there's one of the slides is missing. So then in other legal retention periods, sorry, we're having a technical issue here. 1 second. Okay, so I'm not sure if, yeah, you should be able to see it now. So under the Payment of Wages Act, you will need to keep wage records for 6 years unless you receive other instructions from Revenue. As we all know, working time records need to be held for 3 years from their date of creation, and employment permits need to be held for 5 years or the duration of the employment. Again, employment permit information may contain sensitive information, so do ensure that this data is afforded additional protection. Other employee records that have legal retention periods are detailed in our record keeping checklist, which we'll have up on the SFA website. So moving on, limitation periods and what this means. A limitation period is the length of time that an individual has to make a claim through the courts. So examples of limitations could include some of the following. For example, an employment claim under the Workplace Relations Commission can take up to 1 year. For example, if I make a complaint under the Unfair Dismissals Act, I have 6 months to make a claim. However, this can be extended up to 1 year for an exceptional circumstance. If you wish to make a claim through the civil courts, a person has up to 6 years to make a claim, for example, a breach of contract. And I stated earlier that, and then moving on, if you have a work-related injury, you have up to 2 years to make a personal injury claim. So it is recommended also that you keep recruitment-related data for 1 year, as an individual has up to 1 year to make a claim with the WRC. So how long should we hold personal data when in relation to a claim? So we put here number of years to hold data plus 1 year, and that'll be your retention period. So it's important then in relation to contracts of employment that you factor in both the legal requirement to hold the data and factor in any limitation periods. So in the case of contracts of employment, our recommendation is to hold them for 7 years. So this is our final poll of the day. What is the recommended limitation period to hold a contract? Is it 6 years, 7 years, or 10 years? I've kind of made this one an easy one. It's just more of a recap poll. So that's great. Yep, we've got 100% winners. So we're just giving everyone a minute just to take part. So great. Yep. Pretty much everyone has agreed it's 7 years. So thank you so much for taking part. And that's the last of the polls anyway. Sorry, just getting the screen back on. Okay. So one key area to consider in terms of record keeping and GDPR are health and safety considerations. This is a vast area, and as businesses each have unique health and safety requirements, we'll just focus on 3 key areas. So the first one is reporting work-related accidents. If an employee has a work-related accident or injury, and they are out of work for 3 consecutive days after the day of the accident, this must be reported to the Health and Safety Authority. And these records need to be held for 10 years. The other element you want to consider are training records. Now, this is something that a business can decide for themselves. So you might want to think about, do you want to hold the physical training records for a period of time? Or you may want to consider setting a time period of how long you would hold the information on a database of the training they've received and what certification they've received. And then finally, many businesses have health and safety regulations if they're working with chemicals or other dangerous items. So there may be some specific health and safety regulations that they need to adhere to. Our recommendation is to just check with the Health and Safety Authority to see what those time limitation periods are. And apologies, I know that some of you may not have got to see the slides. It got a bit stuck, but just to remind you that we will actually be posting this recording up on the SFA website under our GDPR section. So just moving on then. So regulatory considerations. So another consideration for keeping personal data for a specific period of time are regulatory requirements. For example, the financial services sector is heavily regulated industry, so your business would need to factor in those considerations. Again, if you work with children, there are a number of regulatory requirements to comply with, so you may need to set those against your personal data that you hold. If your business is regulated, it is important to contact your regulatory body to see what their retention periods are for personal data. And then finally, there are some record keeping requirements under data protection, including the management of consent received and requests for consent to be removed or for data to be erased. And you will need to keep a record of these that it has been carried out in case of an audit or a complaint or a visit from the Data Protection Commission. And then finally, we're going to look at individual business needs. Now, we're very aware that we have a very broad membership base, so it's very difficult to be able to give a one size fits all, but we're just looking at some of the more common themes. So looking at tax and other financial records, in general, these should be retained for 6 years, but do check with your accountant or with revenue to confirm those retention periods. Many of you may also actually be have company law requirements, and that's another thing to factor in with your data keeping records. Another query that we get a lot is on CCTV footage, and again, many members would have this. And one of the main questions I'm asked is, how long can we keep the footage for? The data protection website state that it would be difficult to justify retention beyond a month, except where the images identify an issue, such as a break-in or a theft, and is retained specifically in the context of an investigation of that issue. So in general, our recommendation is hold it for 1 month unless you know that there's been some criminal activity or there's an accident in the workplace that may be needed to be used to defend a claim. And then finally, legitimate business interests. Again, this is really, really broad, so we wouldn't be able to give specifics here. But the main thing to bear in mind is that if there's a legitimate business case to hold on to the personal data, and you can objectively state why you're holding on to it for X reason, the important thing is to document it and detail the reason for holding it, and to put a sort of a time frame around the reason you're holding that data. So ultimately, you are the expert of the personal data you hold as you understand your business best. If you have had no contact with a data subject for several years, and there is no legal or regulatory or other objective reason to hold on to it, then it does need to be removed. However, when you take the time to stop and consider what personal data you have, you will be surprised at what knowledge you already have on the personal data you hold. And as I said before, if there's an objective reason to retain the personal data, document that. I hope that today's webinar has helped you navigate the minefield of record keeping and GDPR and made it a little clearer on how you can either objectively justify retaining the data and feeling more confident in clearing out all the old data that you have. Thank you very much for listening in. And just to remind you, we will be sharing the slides and the record keeping checklist with you by the end of this week. And next week, we will have an FAQ on your questions that you've sent in today. So thank you so much for listening in. It's been great to share this with you. And I have my contact details here if you've any further questions.